It's my great pleasure to speak today. As Tatjana has already pointed out, the research has been done in the context of a book which has just been published by Oxford University Press on internet jurisdiction. And actually, in fact, I wrote the chapter on investigative jurisdiction while I was sitting at the Max Planck Institute in Freiburg. That was actually before Tatjana was one of the directors there about 3 years ago. And I did a bit of comparative research in the area of criminal jurisdiction. The book is quite ambitious. In some ways, you could say it's quite a mad project, because I look at internet jurisdiction starting literally with the technology. It's a starting point. And I look at internet jurisdiction in all different areas, ranging from civil law jurisdiction and private international law, right through to intellectual property, consumer jurisdiction, and also criminal jurisdiction. In this talk, I obviously only focus specifically on cross-border criminal investigation. So here we're talking about investigative jurisdiction. And the point of interest here is, I guess, modern communication technologies and how they have led to a loss of location, which has also been called the unterritoriality of data, particularly in the writings of Jennifer Daskal and my colleague, Professor Ian Walden. But of course, the problem of transborder or cross-border criminal investigations, for example, on social media sites or on cloud compute, or generally in technologies which use cloud computing, is of course not limited to the investigation of cybercrime. In fact, most crimes in the modern age involve data which sits in the cloud, such as I said, social media communications. And compared to the traditional paradigm of criminal investigation, this has led to two fundamental changes of paradigm. So while in the old days, I guess the police would have used physical search and seizure powers to physically go into a building, seize the computers, take them away and examine them, this now has been replaced by remote access to computer data. In fact, most of our data, our communications data now resides not on the actual end machines we are using as users, but it resides somewhere in the cloud because it's remotely stored. So the constant broadband connection and bandwidth we're all now having, including, in fact, this very Zoom conference, is obviously stored remotely in a different location. And this remoteness then obviously leads to jurisdictional issues. The second change of paradigm is obviously the way telephony has changed from traditional fixed line telephone systems, obviously in the old days, going back to the 1980s, owned by the very state who was seeking access, for example, through interception on communications data. Now, of course, this communications data, again, doesn't sit anymore with the national telecoms operator, but because it travels over the top through the internet, it sits with whatever communication service provider, again, such as Zoom, most likely in a distant location, most likely from a European viewpoint, headquartered in the US, perhaps with a subsidiary, for example, in Ireland. So the fact that the data is being stored abroad creates obvious implications for digital investigations, because even in a criminal case where both the suspect and the victim and all the facts, all the location factors are based within the jurisdiction, the communications data might well be in a foreign jurisdiction. So where do we then, which is the link then to jurisdiction for digital investigations? Should it be the location of the data? Should we ask the question basically on which server, on which computer is this data located, and should that state have jurisdiction? Well, it's been argued that obviously the location of the data in the computer world, in the interconnected cloud computing world, is pretty meaningless for three reasons. The first one is obviously mobility. clearly, it doesn't really matter where the data is for the functionality of the internet. The ubiquity of the internet and broadband connections from anywhere and everywhere means that the data can be stored anywhere, and in fact is moved. So some of these technologies, for example, Google, the data is spread over several locations to the point where it's often very difficult or even impossible to identify where the data is actually located. Interconnectedness. The other problem, of course, is that internet service providers do not separate their customers' data according to jurisdiction or according to residence or nationality. So the data is completely intermingled. So it would actually be impossible for internet service provider to literally separate the data in many cases. And finally, there is this whole new technology which allows the data to be completely divided. So data which is presented together, for example, on a social media platform, might well come from different sources. So through technologies such as sharding and inline linking, data which concerns the same set of facts might actually be hosted from different jurisdictions. Because of these technologies, basically the location of the data itself, the physical location of the data, is meaningless. Obviously, a fourth factor here, which I don't mention in the slide, of course, is that data might well be encrypted so that the entity which hosts the data itself might have no access to the data at that point. So given this fact that because of these technologies, there is a loss of location, how have states reacted? Because clearly law enforcement does need to get to the data in a way, in terms of our freedoms. If we don't have law enforcement, we also have no liberty. So to some extent, there is clearly a necessity to do something about that. Law enforcement does need to get to the data in the cloud. And they're basically in this chapter, it's chapter 6 of the book, I develop I sort of categorized the various reactions we have seen into basically 4 basic strategies in order to conceptualize them. First of all, we see an increasing number of mutual legal assistance treaties, so the traditional mechanisms of international cooperation in criminal affairs, where basically states, usually through a treaty, agree mechanisms for cooperation. Now, I guess the crucial thing about mutual legal assistance treaties is that both the requesting and the requested state in their cooperation have sovereignty, in the sense that there is an element of discretion whether data, for example, is being disclosed or not. Obviously, I look at this in much more detail in the book. And we see increasing number of mutual legal assistance treaties. But of course, mutual legal assistance is very slow. It can take up to, well, can be measured in years rather than days, which is often very impractical, both in terms of the sheer volume of investigations as well as simply the time factor in investigations. So there is this whole question whether mutual legal assistance doesn't actually work in the digital age. The second strategy, if you want, is the unilateral extension of jurisdiction. So extraterritorial investigatory jurisdiction by extending investigatory powers beyond the territory. Now, this is, of course, complicated because traditionally, under international law, investigatory jurisdiction is clearly bounded to the territory. So obviously, we would not see normally police entering foreign territory and seizing a computer. That's just not possible under international law. That would be an interference of sovereignty. But of course, the problem here is that states can act remotely. And therefore, the police officers who hack into a foreign computer are still based on their territory while they're taking effect in a foreign country. I'll come to that in a second. The third strategy are, of course, then treaty frameworks for extending domestic investigative procedures on a mutual reciprocal basis. And this is, I guess, a relatively new development. The first examples of this, of course, are the Cloud Act from 2018 in the US, which provides, from a US domestic law point of view, the framework for the US entering into executive agreements with other states in order to enable reciprocal direct access to foreign service providers. In other words, these executive agreements, once they're negotiated and in place, enable US law enforcement authorities to access directly data from foreign service providers, and vice versa. It would enable the foreign country to access data from US-based service providers. The human rights implications of this, of course, is that neither the suspect or the person whose data is being accessed, nor the state to whom they belong might ever know about this. So the direct access requirement basically raises the question of notification requirements. And then the fourth, which I guess was the predominant way of getting to investigative data pre the Snowden revelations, was foreign law enforcement simply asking the foreign service provider to cooperate on a voluntary basis and disclose data on an ad hoc kind of voluntary basis. And as I say, politically, before the Snowden revelations, obviously the US service providers cooperated with foreign police in certain circumstances and then disclosed that cooperation in their transparency reports. Now, sorry about this slightly squashed slide, but I thought it might be useful to give you an overview over these four mechanisms in a little bit more detail. So the first one, as I say, is international mutual legal assistance. It's clearly a coercive mechanism, but is based on a treaty, and it usually includes a whole range of different types of enforcement measures. So ranging from search and seizure, protection orders, and all sorts of other powers. The extension of domestic investigative powers, which is my second strategy on the previous slide, basically has two different aspects. The first one is the power to obtain production orders from third parties, including obviously internet services. Here, the arguments center around the extended territoriality of domestic criminal procedure rules. So a state simply will use its domestic criminal procedure rules and argue that the link to territory means that it has jurisdiction to extend those domestic criminal powers in this way. So it's a coercive process based on the domestic criminal procedural rules of the requesting state. So the examples for that was the famous Belgian Yahoo case. I think there was also a Belgian Skype case. Also the arguments surrounding the Article 18 of the Cybercrime Convention and the guidance note. The other example of extended territoriality and the extension of domestic investigative powers, of course, concern various hacking techniques which states obviously employ in order to get to data in foreign computers, and which are basically involve hacking and various data mining techniques, including obviously open source computer data, for example, in social media sites such as Facebook. So these are coercive as well. They are obviously based again on criminal domestic procedure, and there are obviously specific provisions in various criminal procedure laws which specifically capture this. So, for example, the Belgian Criminal Code contains a rule on this. And for example, in the book I mentioned there's a Danish Supreme Court case which also extends its own search and seizure powers to enable access to foreign computers in certain circumstances. Then the third power, which I already mentioned obviously again in the previous slide, was an essential international agreement such as the US Cloud Act, or the framework provided by the US Cloud Act, the US Executive Agreements. The first of these executive agreements has now been entered obviously into with the UK. Another example for this also is the European proposal for a e-evidence regulation, which would lead to a vaguely similar system between the EU member states, thus enabling the EU member states to ask for disclosure of investigative data from another member state's service provider. And then, as I say, the fourth one is extension of domestic powers, but leading to voluntary cooperation with private internet service providers. So these are not necessarily coercive measures, but are sort of more pragmatic cooperation with the social media companies, asking them for specific items of data. This is obviously more restricted, I guess, in the post-Snowden world, as obviously it's not. There's now a public awareness of a sort of cooperation which sits strictly outside the rule of law. So, while in the chapter, obviously, I describe in great detail, it's a chapter which is very long, it's over 100 pages. I describe in detail these various mechanisms and how they work. But the fundamental challenge, I think, in this area is how do we protect fundamental human rights, obviously including privacy, or generally the rights of the accused, and at the same time, preserve the capability of law enforcement to investigate and prosecute crime, where some of the data is hosted by a foreign service provider in a foreign jurisdiction. So obviously this raises really difficult questions of jurisdiction, sovereignty, and extraterritoriality, both in relation to the actual application of the investigative powers, prosecution and enforcement ultimately, which criminal procedure is applicable. So there's obviously often a conflict of law between two sets or even more, three sets of criminal procedure, and ultimately a conflict between criminal justice systems. And even within the EU, where we obviously have a high degree of similarity, or a certain degree of similarity, maybe I should say, between criminal justice systems, there are obviously massive differences between criminal justice systems. So therefore, the key question really is which state is responsible for protecting fundamental rights under which criminal procedure law? When I was writing the book, I asked myself, why does jurisdiction matter? For some of my colleagues in the tech area, they always think that I'm slightly on an outer limb talking about these theoretical jurisdictional concepts. And the reason I think why it really matters, I guess helping me to motivate to finish the book, was really that 4 very important legal institutions are tied up with jurisdiction. And I think that's what makes it interesting and also complex and important. First one, of course, is the rule of law, checks and balances for executive power, because that's really what we're talking about here, fundamental rights, guarantees and remedies, and citizenship. Because ultimately, I think now a lot of the debate is actually moving on looking at sovereignty, not just from the viewpoint of the state. And Jessica Scherson, who also speaks in this conference and is my PhD student, is very much looking at sovereignty, not just as a question of state sovereignties, but also the individual's sovereignty. I would not necessarily phrase this debate as a question of sovereignty, but I would phrase it as a question of citizenship and identity and allegiance to a state. Because clearly we have this fundamental exchange between, on the one hand, being obliged to comply with the laws of a state, on the other hand, having our fundamental rights protected by the state. And this is the basic social contract, which I think is part and parcel of the notion of citizenship. So because of the difficulty of transborder investigation, I think it's transnational criminal law has now entered the state. So it's a concept which basically tries to capture the legal frameworks establishing the structures necessary to fight crime in this interconnected world. And while a lot of this debate on transnational criminal law focuses on the practicality of enabling transport and the procedures enabling this transborder investigative powers, there is not enough debate really on what this means for fundamental rights and how we can create the structures necessary to actually guarantee international constitutional rights. And here I've relied a lot on the writing of Sabine Gless, who basically argues that this needs to be balanced by a transnational model of international constitutional rights. So in my final part, I want to focus a little bit on the two main examples, I guess, of this developing or emerging transnational criminal law in the context of digital investigations. Obviously, in the EU, obviously the UK is not part of the EU, but the EU has an area of freedom, justice, and security. And this is essentially very strongly based on the notion of mutual recognition. So the idea that, relatively speaking, EU member states have developed systems for criminal justice, and that therefore, because of this broad similarity and also obviously the implementation of the EU Charter of Fundamental Rights and the European Convention of Human Rights, because there is a common standard, that therefore between the member states there should be mutual recognition of for example, investigative orders or the European arrest warrant, etc. But the truth of the matter is that this focusing on mutual recognition because of the equivalence of the fundamental rights across the member states, it is basically a priori test. So basically the argument is, oh, well, we can comply with an order for member state X because we know member state X, generally speaking, protects human rights, so we don't need to double check this order. So basically the issuing state or the requesting state is given the trust to protect the fundamental rights of any suspect or anyone who is subject to a disclosure order. But I would argue that this is highly problematic, and I do this in the book with a number of examples, for the very reason that some of the facts relating to the matter at hand might well be in the requested state. So the requesting state hasn't got access to the right information in order to protect the rights of the subject. So the court, in my view, has put in too much emphasis on this idea of this a priori test, saying, oh yeah, the states all comply with fundamental rights, they can just rely on each other's order, without actually giving the suspect or someone else who is subject to order the opportunity to challenge that order in their own member state. That's highly problematic, and it's really interesting that, for example, in the area of consumer protection, we have specific rules which protect the consumer and make sure that the consumer can sue in their domicile, in their country of domicile. But in a criminal justice context, we say, oh, no, the suspect can somehow rely on the law in the issuing state and they don't need any recourse to the law in their own state. That seems very strange in terms of legal values. So I think there needs to be much more emphasis, not just generally on a priori notion of fundamental human rights, which all the member states somehow have implemented, but there needs to be much harder and clearer systems which give basically a court competence, a local court competence to review or to have some sort of judicial review system in the local place of the person who's subject to an order. And similar problems, of course, arise in the context of the two more specific instruments, the US Cloud Act and the EU Evidence Proposal. Interestingly enough, both these instruments rely on a comity analysis. This is, I think, is the, yeah, I'll be quick, one more minute. So the Cloud Act has given basically the US the power to issue a warrant under the Stored Communications Act to ask a US-based foreign service provider to disclose data, even if that data is stored in another jurisdiction. However, there is a comity analysis involved in that. Comity can be raised if the data doesn't concern a US citizen or US resident, and the state concerned has entered into an executive agreement with the US, In that case, the court can take into account whether this would conflict with the law of the state where the data is hosted. So, for example, the GDPR, say in the case of Ireland. So this is interesting because it's a carrot and stick model which the US uses here by basically saying, sign an executive agreement with us, then we will respect your comity. But even the comity analysis, at the end of the day, only protects states' interests. It's not concerned with fundamental human rights. And the same problem is also evident, obviously, in the EU evidence proposal, which also relies on a comity analysis, but essentially also focuses largely on the interests of states rather than the interests of individuals. So obviously, I don't have time to look at this in detail, but again, in the book, in chapter 6, I look at this in much more detail. Also, the political motivations behind the EU evidence proposal. Because I question, for example, whether the EU Commission uses the EU evidence proposal basically to get a better negotiation power with the US when they're negotiating an executive agreement, with basically saying, look, we've got Ireland, we basically don't necessarily need to access the US service providers in the US. But I think I probably have to leave it here. So I come to my conclusion. Basically, my main argument is, and I will have this in chapter 6, and obviously I will develop this also more in the book, which will come out of this conference. But basically, my argument is that more emphasis basically should be placed on ensuring access to justice and cross-border transnational litigation for data subjects. So in a way, we need to build new structures, not just enabling disclosure of investigative data, but also redress for individuals affected. We need specific and harmonized procedural safeguards for data subjects whose data has been requested, such as a duty to inform the data subject after the event, or actually a review by a special committee, which is obviously something we see in relation to investigative powers on the national level. So maybe we need to create a new structure, I don't know, to create a review mechanism. So basically, we need transnational procedural safeguards instead of just relying on the law of the issuing state. So those are the 3 main takeaways for my chapter, and I guess I have to leave it there. Thank you very much.
Thank you to the WG HART organising committee for what's been a fantastic conference so far. My paper, as Tatiana mentioned at the start of the session, is on unexplained wealth orders against politically exposed persons as a response to jurisdictional limitations and the problems and the potential from a jurisdictional perspective with UWOs against PEPs. Just by way of housekeeping at the start of this and for definitional purposes, the cohort referred to in anti-money laundering circles and increasingly in proceeds of crime circles as politically exposed persons, or PEPs, are comprised of prominent public officials, their families, and their close associates. So that's what we mean when we talk about PEPs. And in terms of unexplained wealth orders are a civil, not criminal, investigative order which may be applied for by UK enforcement authorities against, amongst other groups, PEPs from outside the UK or the EEA. The most famous unexplained wealth order case to date in the UK was that of Samira Hajieva. She was a woman whose husband was the chairman of a state bank in Azerbaijan, from which $100 million disappeared. And Mrs. Hajieva subsequently infamously spent £16 million in HARTs, even though she had no apparent source of income. The graphic on the slide there is the BBC breathlessly reporting on her expenditure. The unexplained wealth order allows enforcement authorities to demand that a PEP, where it's that PEP's UK-based assets are apparently disproportionate to their known income, as was the case in Mrs. Hajieva's case, to explain how they managed to obtain their property, and where respondents do not comply with the order, or where they give an explanation for their wealth which is not credible, the property will be presumed to be recoverable property for the purposes of the Proceeds of Crime Act. And it's then open to enforcement authorities to apply to the High Court in England for civil recovery orders against the properties whereupon they can seize those properties and repatriate the proceeds of those properties back to the victim states of the corruption, the states of origin. So this talk briefly will look first at how jurisdictional constraints in criminal enforcement jurisdiction can result in impunity for official corruption in international law. Second, I'll give a little bit more detail on what unexplained wealth orders are, how they work, and against whom. Thirdly, I'll explain how, even though they are a civil mechanism, their use holds some censorial value or condemnatory value, rendering them in practice akin to punitive criminal measures substantively. And finally, I'm going to discuss how the substantively criminal implications of unexplained wealth orders impact upon territorial enforcement jurisdiction. As we've heard numerous times over the past couple of days, criminal enforcement jurisdiction is primarily based around notions of sovereignty. So jurisdiction for enforcing criminal law is the prerogative of the state, as we know, on whose territory the criminal acts were committed by and large, unless they waive or give consent to another prosecuting body or enforcement body. Grand corruption crimes or official corruption crimes are not crimes of universal jurisdiction. And the territoriality principle, insofar as it applies to grand corruption crimes, is respected in the main anti-corruption suppression conventions. The United Nations Convention Against Corruption, for example, which has 165 states members, requires states to create official corruption offences and extensively provides for cooperation between states to recover stolen assets. So they recognise that it is completely, well, not completely normal, but it is not unusual for officially corrupt acts to result in mass embezzlement of billions of dollars from the state's coffers, and for the PEP in question then to hide that money offshore. But the United Nations Convention Against Corruption does not provide for extraterritorial jurisdiction for corruption offences, nor does it echo the cause of some international lawyers in seeking crimes of official grand corruption to be designated as a crime of a universal jurisdiction. And where, therefore, the PEP's own state of origin does not take any criminal action where there's large-scale embezzlement, for example, and this might either be because of a permissive attitude towards kleptocracy that is endemic, where you have an endemically corrupt government, as was recently the case in Ukraine, for example, or where there's a lack of institutional capacity to deal with that embezzlement and corruption, which is a problem that has bedeviled Haiti, for example, over the past few decades, or just simply a lack of evidence, which was the case in Slobodan Milosevic's domestic trial for corruption and embezzlement in the former Yugoslavia, then the PEP in question will suffer no criminal consequence. Because other states cannot take action in the context of grand corruption, territorial jurisdictional constraints allow appeals to legalism to triumph, essentially, over appeals to justice, because the presumption against extraterritoriality operates in favour of the kleptocrats seeking to act with impunity. There is scope for this to change, at least where misappropriated assets are held in the United Kingdom, with the advent of unexplained wealth orders. The slide shows the tests, the statutory tests under the Proceeds of Crime Act that need to be satisfied by law enforcement authorities seeking to obtain an unexplained wealth order, compelling a PEP to explain their source of wealth. So first of all, the respondent brother must be a PEP. Secondly, who holds property in the United Kingdom. Thirdly, that is worth at least £50,000. And fourthly, there must be, quote, reasonable grounds for suspecting that the known sources of the respondent PEP's lawfully obtained income would have been insufficient for the purposes of enabling the respondent to obtain the property. Unexplained wealth orders are a hybrid model which incorporate aspects of criminal and civil law paradigms. So formally speaking, they're civil law measures. They involve High Court applications, the civil division of the High Court. The respondents to unexplained wealth orders are civil respondents, they're not criminal defendants. And no prior criminal conviction or even formal evidence of criminality on the part of a PEP is necessary to obtain an order. However, based on the way they operate in practice, they are expressively redolent of the criminal law. And it is this which is the issue that then has implications for extraterritoriality in practice. So the ways in which they resemble the criminal law include, for example, the fact that they involve a state-made claim of criminality against respondents, the fact that they're a measure aimed at achieving criminal justice objectives of deterrence and pursuing the proceeds of crime, and most notably, where they've been used in practice to date, they've involved extensive condemnatory publicity attaching to the measure. So respondent PEPs with no explanation for their wealth suffer a lot of public stigma and censure typical of criminal convictions. And that was very obvious, for example, in the Hajieva case mentioned at the start of this talk. The general impression that the public is left with is that Mrs. Hajieva has done something wrong, even if it's not necessarily a formal criminal conviction. So based on all of this, unexplained wealth orders against PEPs offers a seductive solution to the de facto impunity wrought by criminal enforcement jurisdictions' territoriality requirement. And crucially, where an unexplained wealth order is used, no formal conviction ensues where enforcement authorities obtain them. And this leaves the door open for the corrupt PEPs to be prosecuted in their states of origin in the future without violating double jeopardy principles. But an argument might be made that the effect of the unexplained wealth order process is essentially to prosecute in all but name, thereby infringing the state of origins, so the so-called victim states, territorial prerogative to enforce action, to take enforcement action against the crime and the criminals in question. And I look at this proposition further by looking at what we talk about when we talk about criminal proceedings. First of all, it's worth looking at the notion of criminal charge or criminal proceeding as it's conceptualized by the European Court of Human Rights. And the classic test, of course, is set out in Engel versus Netherlands. In that case, the court encourages us to look first at what is the classification of the proceeding in the national law. But we know that often that doesn't yield very useful results because, for example, sometimes jurisdictions might formally classify a measure as civil in law in order, for example, to circumvent Article 5, 6 and 7 criminal procedural safeguards under the European Convention of Human Rights. So if looking at the first limb yields no fruit, the court encourages us to look then either at the nature of the offence and or the severity of the state response in determining whether something is truly criminal rather than merely administrative or civil in nature. So the third limb, severity of the state response, directs us to look at whether a measure's outcome can be said to be punitive in nature rather than merely an administrative sanction. From a criminal theory perspective, Henry HART, in a widely endorsed discussion of what distinguishes criminal process from other processes, theorized that punishment for crime has two components. It's got a harsh treatment or criminal sanction element, so traditionally fines or prison, and the second part is a public condemnation or stigmatizing element. And Hart noticed that incarceration is possible without a criminal connotation. For example, you can have debtors' prisons or psychiatric patients can be incarcerated in each case without a conviction. And similarly, fines without a criminal connotation are simply penalties. And a good example of that would be parking fines, for example. They would be regarded as morally neutral sanctions. But it's the public condemnation element that elevates those measures to criminal measures. And this public condemnation or stigmatizing element is present in the use of unexplained wealth orders. The unexplained wealth order serves the same communicative purpose that Joel Feinberg has identified the criminal law as serving for society. A publicised unexplained wealth order application affords the state the opportunity to disavow corrupt conduct, and the action demonstrates to the public and to the international community that the laundering of corruptly acquired assets is not tolerated within the United Kingdom where it's used, broadcasting the UK's symbolic non-acquiescence, to use Feinberg's term, to this practice and serving a communicative condemnatory purpose, and thereby deterring others from undertaking the same practice. And then the repatriation of the relevant assets serves a restorative purpose. In fact, the publicity surrounding PEP-based unexplained wealth orders to date has been so prominent and widespread that it could be seen as tantamount to its own form of sanction or HART treatment. So far, publicity on PEP-specific unexplained wealth orders has been prominent and widespread. It has impugned the integrity of the respondents, and bearing in mind that these are PEP, politically exposed persons respondents, they often hold and rely on positions of public trust. The media coverage on PEP-specific unexplained wealth orders doesn't generally elaborate on the finer points between civil recovery on one hand and criminal forfeiture or confiscation on the other hand. And indeed, the expression proceeds of crime is used for both. And because the respondents involved are often people who rely on public trust, it can have wider adverse consequences for a respondent where an unexplained wealth order is used against them. So in other words, the process itself is tantamount to harsh treatment or punishment, one might argue. And in this way, the unexplained wealth order, where it's used and sustained, might be regarded as substantively tantamount to a criminal measure. It arguably punishes and achieves crime control objectives and therefore substantively circumvents territoriality requirements by imposing a criminal consequence on corrupt PEPs who have moved and laundered their corruptly acquired assets in the United Kingdom. If we accept unexplained wealth orders against PEPs as substantively punitive in outcome, then this might have implications, of course, for criminal territorial jurisdiction, and it might also have implications for non-intervention principles, because it involves a branch of the UK executive imposing judgment on the political class of another state. Importantly, it might have more expressive heft than a country merely imposing sanctions against targeted sanctions against corrupt individuals, because it's a formally adjudicative rather than a political response to corruption. And incidentally, Saskia Hufnagel and Anton Moshenko have together written compellingly on crime-based targeted sanctions as similarly having a de facto criminal effect and similarly having the potential to breach territoriality principles. Any measure which has the capacity to encroach upon international law principles through its substantive impact should be approached with caution. Alejandro Chapman yesterday enumerated the systemic and normative arguments enacting against the presumption of extraterritoriality, and his concerns around the neo-colonial imposition of values on other states might be particularly acute where the UK is perceived as exercising territorial jurisdiction and contravention of international law conventions, or at best, if we regard unexplained wealth orders as falling within a liminal space between a formally civil and substantively criminal measure, and to use Cedric Reingard's useful expression for Monday, the UK might be seen as acting in an illegal, not illegal, illegal way from a jurisdictional perspective. In those circumstances where it seems that no prosecution will be instituted in the PEP's state of origin, then allowing the presumption against territoriality to preclude the operation of unexplained wealth orders will, in practice, allow for a victory of strict legalism over justice. And the idea has been floated over the past couple of days for a very cautious revisiting of strict territoriality principles where criminal actions have human rights consequences. The ideal option would be for responses to impunity to corruption to be developed at an international level. But the level of political wrangling to get something as relatively non-contentious as even the United Nations Convention Against Corruption passed renders this unlikely. And in the negotiation of that instrument, for example, the states parties couldn't even agree on a definition of corruption. To conclude, therefore, pending any developments at international law level, and given the impunity umbrella created in the context of corruption by the territoriality principle, unexplained wealth orders represent possibly the least worst option for targeting corrupt assets hoarded in the United Kingdom, notwithstanding the fact that they may breach against the territoriality presumption in practice. Sorry, the territoriality, the presumption against extraterritoriality in practice. Thank you very much. A copy of my paper is on the website, which sets out the ideas in more detail.
Maybe while I'm trying to share my slides, I just can add a few words how I came myself, so to say, to the topic of e-evidence, cyber investigations, or investigative jurisdiction in the cyberspace. I had the privilege to have been appointed in 2017 as a special advisor to the Justice Commissioner of the EU, that time Vera Jourova. And this was the period when the European Commission started its work on the so-called e-evidence regulation, the evidence package. We have been talking about it during the last 2.5 days. So this is not what I'm going to talk about, strictly speaking, but it was a very inspiring period because at the same time, the works on the US Cloud Act were ongoing, and I could see a little bit and follow the discussions in-house how these two legislative proposals were shaped, or at least were perceived and understood on the European side, so to say. Now, I am also working on a book which is hopefully soon appearing with Springer on all of these experiences. I'm doing it together with my former colleague, Dr. Gavin Robinson. And one of the aspects that I would talk today is really how this situation of conflicting laws can or cannot be resolved through committee, and how we may eventually converge. And I may imagine that the title of my presentation also motivated the organizers to move my presentations towards the end of the conference, because apparently I think one of the questions that we would like to see answered, or where we are looking for an answer, is how we will converge in this very complex area of enforcement jurisdiction in globalized and cyber criminal investigations. So I would just start, I think, with a citation, and this is from Vice President of Microsoft in the Microsoft case, and I think it's well describes, I think, the situation. If every country asserts extraterritorial jurisdiction, then everybody gets everybody's data. It has been already evoked today that traditionally criminal investigations were local, evidence was local. So if investigative bodies needed evidence outside the territory of the investigative authority, they ultimately had to use mutual legal assistance. And this entire paradigm has been put into question through globalization, but also through shifts in technology, which ultimately very often give rise to a situation where a user subscribes or uses services in a country which is not its own country. Maybe the data is stored not even in the country of the service provider. Resulting in a situation where eventually these internet and cloud service providers have control over the data, the information, the evidence, which is available to law enforcement authorities. And the private sector, and here I refer to the internet and cloud service providers, exercise this control through a number or a combination of technological, business, and policy decisions. This is a very delicate question and a very delicate setting, I think, of the private sector. I will not go into this because I believe that Ute will talk about the role of the private sector later. But just to frame the discussion, I think it's important to keep in mind that cloud data is essentially differently experienced from the viewpoint of the user and from the viewpoint of the law enforcement authority. Whereas for the users, there is no territorial limit in the cloud. There is an obvious limit for the law enforcement authorities because they can exercise normally their powers only within their national territory. I think it's also fair to say that it is a fact that a large majority of these cloud services and the data is held by US-based service providers. Therefore, in our traditional understanding, if European law enforcement authorities would like to have access to this data, they have to use the mutual assistance scheme. This morning, Julia, in her wonderful presentation, already explained that there is a lot of argument, or one could even say mounting evidence that mutual legal assistance does not work. It's too burdensome, it's too slow. I believe as we are moving towards convergence, and I will come back to this at the end of my presentation, it's interesting to see that now there is an emerging argument and controversy within the EU and especially in the European discussion, whether this is actually true. Is MLA really outdated? Is it really so slow? Is it really so burdensome? There are certainly data, and I think most of us is aware of this data. I don't want to repeat it here today, but it's important to keep in mind that if a European mutual assistance request arrives on the other side of the Atlantic, it's certainly not necessarily a priority on the desk of a US prosecutor who might have other tasks as well. And this may certainly become even more critical as there might be a large volume of these kind of requests as MLA is to be used. But ultimately, in order to actually make the MLA system meaningful and functional, we need to have clarity which territorial state has jurisdiction over the data in interest to the enforcement authorities. And this is where the entire discussion about data location and connecting factor starts. We have already a lot of discussion on the territoriality of the data. I think we are all aware of the interesting Syrian approach of Jennifer Daskal and others saying that data is essentially different than everything else and it's unterritorial. What I believe is interesting to see that in lack of better mechanisms to facilitate the law enforcement access cross-border to data, we see genuinely two approaches how relation. One, and I believe this has been at the heart of the discussion this morning, is the unilateral extraterritorial enforcement jurisdiction. It has been, I think, in large detail explained by Julia, so I will not repeat it today, but the idea essentially is that law enforcement authority can go directly to service providers whose services are accessible, so to say, on the territory of the enforcement authority, even if physically the service provider is located maybe on the other side of the Atlantic. Certainly, the EU's e-evidence proposal subscribes to this unilateral extraterritorial approach, as Oriola, I think, has very nicely highlighted it in the previous section. There is, however, also another approach, which I think is quite striking, that some of the countries go down the line of very stringent data localization requirements, which require the service providers to save or at least mirror the data on the national territory. Obviously, there is some scholarly questioning or concern whether the access based on data location can be normatively justified, because ultimately data location is a decision of the private sector, of the service provider. It's a decision which is based mostly on efficiency grounds, energy costs, tax rates, and other business decisions of the private sector. But what we see today is, at least both in the EU as well as on the other side of the Atlantic in the United States, is an increasing assertion of unilateral extraterritorial enforcement jurisdiction. Now, from a legal perspective, there are two, let's say, sets of regulatory approaches which emerged. One is the US Cloud Act, which is in force, and the EU's e-evidence regulation, which is a proposal highly contested and debated in the EU. In the absence of a jurisdictional rule, these unilateral approaches, of course, create potent conflicts of jurisdiction, with ultimately the question that we have to answer today is whether we have a conflict of laws in today's setting, which is basically the US Cloud Act and the existing set of European rules, which is mostly the GDPR as well as national rules. And if we have a conflict of laws, who will decide between sovereign interest? So I start with the conflict of laws, which was a very well exposed in the Microsoft Ireland case. We are talking here about data of EU citizens located in the EU, and the service provider is compelled by a US order to serve this data to the US authorities. And already in the Microsoft case, we saw an emerging discussion and very different viewpoints to which extent the GDPR, the General Data Protection Regulation of the EU, acts actually as a complete blocking statute, which would actually prevent the transfer of data of EU citizens to foreign authorities without a mutual legal assistance agreement. And without going too deep into the data protection discussion, the starting point is that essentially we require mutual legal assistance for data transfers to third countries under the GDPR, and data cannot be transferred unless there are certain conditions met. But there is an interesting exception in Article 49 of the GDPR, which allows for a derogation based on public interest. And in the Microsoft Ireland case, the entire controversy was about how to interpret this public interest derogation. Unsurprisingly, the US government and Microsoft took diametrically different interpretations on this question. The US government arguing that the public interest derogation must ultimately also encompass the interest to investigate and prosecute crime. So the GDPR would not function as a blocking statute for transferring data. Microsoft took, obviously, and unsurprisingly, a rather reserved approach, actually aligning its own interpretation with that of the Irish Data Protection Authority, saying that a public interest exception would apply essentially only to public sector controllers and not to Microsoft. The European Data Protection Board also submitted in an amicus curiae its own interpretation on the applicability of Article 49 and the scope of the public interest exception, saying essentially that EU data protection law provides that existing international agreements, such as mutual legal assistance agreements, must, as a general rule, be obeyed when law enforcement authorities in third countries request access or disclosure from EU data controllers. Circumventing these mutual legal assistance arrangements would amount to an interference with the territorial sovereignty of an EU member state. Now, if we follow the interpretation of the European Data Protection Board, then the GDPR would actually, in this understanding, function as a blocking statute, unless there is mutual legal assistance or other EU legal basis, which can be another agreement. Therefore, if we just take into account the data protection acquis, it seems that this data protection discussion is very much favoring a mutual legal assistance or a treaty-based approach vis-a-vis to the e-evidence regulation, which is advancing and advocating for a direct contact and production orders directly served on service providers. Assuming that there is actually a conflict of laws, this is something that on both sides of the Atlantic was very much within the scope of the reflections on the instrument. And interestingly, both the Cloud Act and the e-evidence proposal have certain rules on committee. We had also a very interesting exchange with Michael and other colleagues in the previous session on committee. I think what is interesting to see that, in my view, none of these committee provisions, either in the US Cloud Act or in the e-evidence proposal, really give us a hint how to resolve conflict of jurisdiction. The US Cloud Act, in its first part, establishes a procedure which allows the provider to move to a quash based on committee grounds. And then the reviewing court has to consider what the Cloud Act calls the totality of the circumstances. Now, this totality of the circumstances, and here I agree with Julia's presentation this morning, essentially refers to state interest. What is the interest? Because the Cloud Act gives certain hints how to actually resolve this conflict by looking into the interest of both governments, looking into the location and the nationality of the person whose communications are being sought, the likelihood that the service provider would be subject to penalties if disclosed the data, and so on and so forth. Certainly in the Cloud Act, in the committee provisions, we don't read much about fundamental rights, but even beyond that, and that is my point, I believe it's very difficult to see how the reviewing court will actually decide by considering the totality of circumstances. If we now look at the approach taken by the EU in the e-evidence package, there are two articles in the e-evidence regulation proposal which deal with conflict. And here I think there is more consideration to fundamental rights, in the sense that Article 15 says that if the disclosure would violate fundamental rights of the individuals concerned or the fundamental interest of the country related to national security or defense, then the service provider can send a reasoned objection to the issuing authority. And in addition, in Article 16, there is a possibility for the provider, also based on other grounds. Similarly to the Cloud Act, I think we see little guidance from the EU how such committee questions could be decided in the issuing member state. How would a court in an issuing member state actually assess these conditions? How could service providers appraise fundamental rights situations or fundamental interests of certain states? But what strikes me even more is that the modifications, which then were subsequently, at least in the discussions in the EU, proposed, how would these modifications meaningfully improve certainty and clarity on deciding conflicts of laws and deciding between two colliding sovereign decisions? And in my mind, and I believe this is how convergence will eventually emerge, none of these legal instruments are actually the instrument to resolve or have even the capability to truly resolve comity. And if conflicts of laws and jurisdictions in a transatlantic context should be systematically prevented and resolved, we would need for that an international agreement on cross-border access. Now, such international agreement is certainly not easy to design because we have a number of interests and aspects to be taken into account, including the informational privacy of the users, committee, the business interest of the, or simply the interests of the service providers, and national sovereignty over data located in the national territory. We still have territorial jurisdiction and concepts of sovereignty in national law, and this is not abolished by cyber investigations. What I believe is particularly difficult, and where probably the EU position still needs to further mature, is how to resolve inconsistencies within the EU's own approach. Shortly after the publication of the e-evidence package, the Commission has been very heavily criticized for being inconsistent in its own approach, and inconsistent, so to say, from an EU constitutional perspective, in the sense that the European Union's area of freedom, security, and justice is a law enforcement area, or as Jonathan termed it in the previous section, a single area for law enforcement based on mutual recognition, and also on high standards of fundamental rights protection. So we have certain simplified ways of cooperation based on mutual recognition on the basis of mutual respect for fundamental rights. Now, this area of freedom, security, and justice also functions as a shield externally towards violations of access to data by third countries, which could violate, so to say, EU data protection rules. And what was criticized a lot after the publication of the evidence package, that there is an inherent tension between the European Union, on the one hand, in the Microsoft Ireland case, supporting very strongly Ireland, who argued in that case territorial sovereignty over the data located on Irish territory. So in the data protection context, data location was a solid argument, also upheld by the Commission and supported by the Commission, whereas in the context of the proposal for the evidence regulation, the Commission rather got away with the argument that data location mattered. So this is one of the tensions. But if you listen to Julia carefully this morning, I think that there are further tensions in the EU's argument. We see also that in consumer law, I think that was the example this morning, there are also different grounds for accessing remedies in the issuing member state than as foreseen in the e-evidence regulation. So ultimately what we see is that there are many tensions in the EU's own approach and its own acquis. And I believe as long as the EU does not resolve these tensions and takes a coherent approach, it will be difficult to move towards convergence. But this move is already taking place because, as we all know, the EU is negotiating an executive agreement based on the US Cloud Act with the US. And the US Cloud Act, at least this is the understanding of the US government, is a baseline, is a floor, so to say, to start the negotiations, but in an executive agreement, further aspects and additional provisions can be added, and these additional provisions can then take care of a range of issues like notice to the target person, protection of fundamental rights, enforcement mechanisms, and so on and so forth. And it's the line of pursuing the negotiations with the US on an executive agreement. There is a very interesting parallel development in the Council of Europe. We have just seen the publication of the second draft protocol to the Cybercrime Convention, which is proposing a sort of expedited or express MLA procedure. So we still see that we have very different approaches. Here I come to my conclusion. I think that there is a lot of work done on both sides of the Atlantic into tackling this question, but the approaches are still relatively far away. And we have even a lot of tension in the concepts and approaches within the EU. So there is certainly much more work that is needed in order to reconcile these approaches as we move on to convergence. Thank you very much.
Talk about private platforms today and the role in law enforcement in the 21st century. It's going to be, I'm going to offer a fairly theoretical perspective and start off by locating these platforms within general internet regulation, then move over to jurisdiction, and then I provide 3 different perspectives of how we might construct and conceive them as quasi-public law enforcers in the 21st century. And I apologize about the background noise. There are builders in the house. So I told them to be quiet, but it's only so quiet the drill can get. So my apologies. Okay. Now, transit substantive network regulation. I've worked in internet regulation for quite a long time, probably 20 years. Jurisdiction was my starting point, but I've looked at other things since. From my perspective, there are 4 main trends visible have become apparent in the last 5 to 10 years in network regulation. And here, these are the 5. They're overlapping. but they're also distinct in their own right. So one, I think there's a shift from a preoccupation with political and moral content regulation to the regulation of the economic effects of network actors. I've given you here a couple of examples, recent examples, so you've got them. The Australian news media and digital platforms mandatory bargaining bill, which was recently in the news because Facebook reacted or potentially overreacted to the requirement to pay for sharing news on Australian social media users. I think they have since come into an arrangement with the Australian government. A prominent example where it's very clear that it's directed at the economic effects of the large platforms is the EU platform to business regulations, which came into force last year, and which deals with basically fairness and transparency requirements of platforms hosting businesses, and includes delisting activities, rankings, and the like, and their terms and conditions. So this is one trend. Another trend in internet network regulation is there's been a move away from immunities and reactive duties to proactive duties. Sometimes the immunities, as in the Digital Service Act proposal of 2020, the immunities are still retained, but conditional on much more extensive obligations of the large platforms. In fact, in the EU Copyright Directive of 2019, the Article 14 immunity of the e-commerce directive is simply disapplied. Yeah, so there's certainly a greater expectation on platforms and sometimes on other intermediaries to take a more active role in regulation. Next, there has been a shift from a focus and narratives about data and content, about information and content to data. Yeah, and this shift basically, I think, is reflective about, one first question is, what's the difference between data and information and content? As far as I can see, there's a type of hierarchy that starts with data, then information, and then knowledge. Data, I think, refers to much smaller pieces of information that are by themselves perhaps often meaningless, but that become very valuable in the aggregate. This information, this data has been collected essentially through the rise of the Web 2 and smart technology, and involves all types of data that was at the first stage of the internet was simply not available. We've had a lot of discussion about, I've given a couple of examples, I'm not going to talk about it, but we are talking today not about information sharing, but data sharing. And here you've got a couple of examples. One, the European Justice case, once again holding the Privacy Shield invalid, and thus the data sharing with US authority, and on the other hand, the Microsoft case, which Katalin has talked about already in some detail. Now, the final shift, which is really the most important from my perspective, is the shift from intermediaries to global platforms. So in the olden days, which is not that old at all, maybe 10 years ago, we talked about intermediaries. The focus has become much more narrow. Yeah, we are now looking to a particular subsets of intermediaries, and these are the global platforms. Now, I need to change to my next screen. Oh, okay. That was easier than expected. Okay. Now, so here I'm also moving over to prescriptive jurisdiction, and I'm looking at the regulation and the expansion of regulation of global platforms by states. I've listed here in some ways quite randomly recent examples that have been directed almost always, but not entirely always, at the platforms. The most well-known one is the German network enforcement law, where the jurisdictional hanger, the jurisdictional connection point, was not simply providing services to users in Germany, which used to be the sort of the link upon which states relied upon to impose their regulation on foreign providers, but it becomes, the link is that you have to have more than 2 million users in Germany. Now that is a shift. That didn't used to be the case. And you can see it being replicated in all those instances which I've highlighted in red on the slide. Yeah. Now, what does this shift actually indicate? Well, from an international law perspective, I think it retains basically a focus on the effects doctrine, but actually it's not the mere effects which states rely upon, but substantial effects. Yeah, so it is a form of targeting, but it is saying, okay, only those companies that have a real substantial effect on our territory shall be subject to these fairly onerous obligations. And, you know, sometimes we are talking in the first 5 examples, we are all talking about content regulation. So content takedown obligations, yeah, dealing with hate speech, responding within certain short windows to hate speech. And here it is very clearly an example of criminal jurisdiction on some level being imposed, given to online platforms. Then you have also in Article 17, again, of the Copyright Directive, the platforms have the duty to take down copyright infringing materials. And then finally, the Australian one, where platforms must pay for sharing news. Okay, this is all I want to say on prescriptive jurisdiction. Here we are still talking very much about regulation of global platforms. Now, when it comes to enforcement jurisdiction, the focal point is still on platforms, but actually what's happening here is that it's no longer regulation of platforms, but regulation through platforms. Platforms become the enforcer or become instrumental to state enforcement. So I've divided this section into 2 areas. Yeah, on the one hand, platforms as they being seen as giving access or potentially access to very valuable data. And we've had a lot of discussion about which platforms should when be obligated to share this data. Yeah. This is not always under the heading of obligation. Sometimes platforms, in fact, share the data voluntarily. And in fact, that is the very deal right from the beginning. So I've provided here a link to a news story which talks about Amazon doorbell, Amazon entering into various partnerships with hundreds of police departments in the US, whereby they are basically saying, okay, if you promote our doorbell to users as a basis of, on the basis of security, enhanced security, and so on, you will also, in return, you get access to the data which is collected through the webcams on these doorbells. Yeah. So sometimes, of course, as in the Microsoft case, these companies have resisted the attempts by the state to get the data. Sometimes they volunteered. From a user perspective, one of the questions is always, to what extent were you aware right from the moment go that this might be happening? And I'm sure very many users who ask for DNA tests and who gave their DNA to genealogy websites like 23andMe, they would be rather concerned and surprised to find out that this actually, the DNA repositories of these sites become extension of for police investigations and criminal law enforcement. Now, I don't really want to say any more about that, just to say that this is one of the roles platforms have been playing, and you can see why they are highly attractive to law enforcement, state authority. In many ways, I think actually their role is even more controversial and even more enlarged, where they are not instrumental to state enforcement, but where they become complementary to law enforcement. And here again, I'm talking about the role, for example, platforms play in taking down illegal content in response to notices by users. Here platforms ultimately enforce the law, but implicitly also make the law. They are making the law by making decision what is and what is not hate speech in a particular country. And I did think it was very interesting how Mireille Hildebrandt in her first talk talked about criminal law actually reflecting the spirit of the political community, the demos, that is very unique to each community. And suddenly that spirit is being, or that responsibility of interpreting that spirit is handed over to a global corporate platform to make those decisions. I can absolutely see why law enforcement might do that, because we are talking about here very cost and time intensive and resource intensive activities that I suppose law enforcement rather not deal with by itself. And, you could say an equally wide discretion was given to Google when it had to interpret the right to be forgotten in response to user requests for delisting of sites on their search results inconsistent with the GDPR. Okay, now 3 perspectives. So, and regulation through platforms, law enforcement and lawmaking through platforms. I'm giving you here 3 perspectives on the state-corporate platform relationship. The first is one of political economy, where you could say the state and the corporation enter into a mutually beneficial bargain. The second, I will very briefly look at legal history. And the third one offers a very brief constitutional law perspective. Okay, coming to the political economy perspective. So what bargain is being entered into? So you have here the territorial state on the one hand and the global platform on the other hand. Each have a lot to gain from each other. The platform wants access to markets. And we have heard about this actually very openly and frequently in the context of China. These US providers, they are very keen on the Chinese market, but of course there's a price to be paid. So they want access to lucrative markets, but they also want the protection of property and contractual rights in the main. So I think these are the sort of core legal concepts which are absolutely essential for economic activity. So global platforms are not anti-state per se, but and in fact are in many ways reliant on the institution of the state to operate. But of course, they want to minimize a lot of the obligations which comes with entering the market. So the territorial state in return has increasingly been imposing on these core platforms gatekeeper responsibilities. They always used to be there, but they are definitely expanding. And they're not just expanding in China, they're expanding in liberal democracies to a great extent. And I'm not saying this is good or bad, I'm just saying this is how it is. There's increasingly also financial compensation expected from global platforms, considering, the economic benefits they get from the access to markets and to what extent they actually undermine other advertisers, including media. And finally, there's access to data. So the territorial state also asks for access to data. And this is where these data access requests and production orders fall into. And I can fully see why states would want this as a bargaining chip or as a price for the access to the markets. And clearly it also underlies those decisions which we have had from Belgium against Skype and so on, is saying, well, if you are using our markets, you should also have certain responsibilities to give us access to data about the users in this market. Okay, so this is a political economy perspective. A legal history perspective gives us the potential perhaps to reconceptualize the global platform as something far more akin to the state as we normally would see them. Yeah, so I've given here a definition of, you might say, either the state or the corporation as an entity to give name. This is obviously not a legal definition. An entity to give name, voice, and standing to a collectivity of individuals to govern itself internally and to be represented or to act as one externally. Now, the similarity, so both state and corporation are ontologically very similar. Yeah, and this similarity goes back as far back as Thomas Hobbes in the Leviathan, where he defined states, or the state as the commonwealth, when a multitude of individuals, when a multitude of individuals covenant with each other to give, and I'm not going to read it all out, to give someone or an assembly of men to be their representative. And he talks about the state being an artificial soul of an artificial body. Yeah, very much as how we today conceive of the corporation. And in fact, Hobbes took the medieval idea of the corporation used for universities, towns, and so on to basically conceive of the outlines of the modern state. Yeah, for the very same reason was he opposed to the corporation. He didn't like the corporation because precisely because it was too similar to the state. Yeah, and he said the corporation is, I mean, this quote is quite famous, and he says, well, the corporation is something that weakens the state and tends towards its dissolution. And it's like a worm in the entrails of a natural man. Yeah, so he said corporate charters were donations given by law, but were also exemptions from law. And there's a very interesting political geographer, Joshua Barkan, who said that actually corporations and the state are in this sort of paradoxical relationship whereby they are both the product of law and grants by law, but at the same time they create inroads into law and exemptions from law. So a corporation can govern itself internally, and you might say when it becomes a monopoly, it is also govern itself in relation. It's also governing the market. Now, one of the useful thing which might come out of this sort of legal history perspective is to conceive of corporations and certainly of these modern platforms as a form of decentralized government. Yeah, these platforms are not private in the sense of being clearly below the state. They are equal partners, and when you see the sort of the bargaining which goes on, and sometimes very directly which goes on between corporation and the state, it would be, I think, wrong to see them as the sort of hierarchical, as we lawyers tend to do, as this hierarchical setup where the state is at the top and the corporations are below. I don't think this is applicable to the platforms. Now, this is the final perspective. So this is a much more sort of, I suppose, grounded legal constitutional perspective. If you were to conceive of these large global platforms as decentralized private regulators, private is problematic word, so maybe just as decentralized regulators, one of the questions you would have to ask, what is their distinguishing features? What are their distinguishing features? To what extent are they aligned and distinguishable from state authorities? So I'm not saying they are like the state, but I'm also saying they are not like any old private business. Of course, we've had this sort of tension before. In the sort of public-private binary, there might be existing useful concepts that allow us to think about these platforms as quasi-regulators, and here I've put here public service providers, public utilities, and infrastructure providers might be a useful starting point to think about them. And then there are the other questions of democratic legitimacy, accountability, and human rights applications. So all these questions have already figured in the literature, but I think they are also very important in, I suppose, conceptualizing the key role played by platforms in making and enforcing law, and thereby, to at least an extent, displacing the state. Thank you.
My theme is concurrency, conflict and compliance, service provision in a global economy. And what I mean about service provision in a global economy is the obvious fact that, given the interconnected global nature of networks, manifest most obviously through the internet, service providers have access to a global marketplace. And taking the theme of the conference, that access to a global marketplace comes with a jurisdictional cost. And that's really one of the themes of what I want to talk about, that jurisdictional cost. And that cost, I think, comes in those three areas that form the title of my presentation. It comes in the form of concurrency, concurrent jurisdictions being applicable to the same activity. It comes with conflict because divergent laws can mean that a service provider in one jurisdiction providing services into another jurisdiction may find itself in conflict with the laws of one or other jurisdiction. And thirdly, the issue of compliance, because as a service provider, generally as a corporate entity trying to comply with this concurrency and conflict, that is clearly a cost of doing business. A perfectly legitimate cost, but it is a cost. So the first aspect is, of course, the provision of global services through, for example, one entity can get access to markets throughout the world, and everybody's very familiar with that. And the particular service providers that I want to focus on are those that are providing communication services. And I'll come back to what I mean about that in a moment. But the link to criminal law is because those communication service providers constitute an incredibly valuable forensic source in criminal investigations, whether it be purely domestic in nature or whether it be international or multinational in nature. Service providers provide a forensic source in terms of the activities of those online cyber criminals. And clearly law enforcement have needs to get access to certain types of data from those service providers. And so service providers aren't just having this access to a global market. Part of the concurrency is they are subject to law enforcement needs and demands from multiple jurisdictions, and that gives rise to concerns both from a state perspective, from a human rights perspective, about the extent to which those concurrent and conflicting demands place the service provider in a very potentially difficult situation. But at the same time, we know that those service providers, as a form of mediated access, to the extent that they can control what they disclose, who they disclose to, can play a very important safeguarding role in terms of human rights, as remarked upon by the Court of Justice, the European Court of Human Rights, in the Zakharov case. The service providers are one of the most important safeguards against abuse, because law enforcement can't get access to this data directly. They have to go and ask a service provider, and that intermediation provides an opportunity for safeguarding. So this global environment gives us this need to manage jurisdictional conflicts. And one of the ways in which we manage jurisdictional conflict is clearly through international agreement. And in the area of cybercrime, we've seen the UK-US bilateral agreement in 2019. We're seeing current negotiations at the Council of Europe level with regard to a second additional protocol to the Budapest Convention. So international agreements is an obvious way of trying to resolve of jurisdictional conflict. But there is a second order of mechanism by which states are trying to address concurrency and conflicts, and that is through the introduction of comity processes into cross-border access to data from service providers, and that's really the focus of my presentation. Is these comity processes, which, whereas international agreements are obviously executive in nature, comity processes are judicial in nature. They are interest balancing exercises whereby one state may agree to exercise restraint in not imposing its legal order upon a party because of some greater sovereign interest or interest from the other country. And we see this most manifest in both the Cloud Act from the United States and the e-evidence proposal published by the European Commission a couple of years ago, which is still going through its legislative process. Both of them adopted a comity process. And what is of interest to me as part of that comity process is it identifies a series of different entities and interests that participate in that comity process. The obvious ones of governments are there, but we also see the interests of the victim, the person that's harmed by the criminal activity. But of particular interest to me is service providers are recognised in both the Cloud Act and the Commission's draft as interested parties, as being part of that interest balancing exercise. And not only that, they are not only interested parties, expressly interested parties, but they are also the initiator of the claim. And those dual roles as initiator of the comity process as well as a interested party within that process is what I want to touch upon in this presentation. Now, I just want to return to this notion of what a service provider is. You know, as any good lawyer, we have to define our terms. And the point I'd really just to make, 2 points I'd like to make is it's how we define what constitutes a service provider is obviously a jurisdictional issue and has undergone considerable debate over recent years, and is why one of the reasons why I think this is an important issue for us to consider, because as of the 21st of December 2020, so relatively recent or very recently, European telecommunications law was reenacted through the European Electronic Communications Code, and it redefined what constitutes what is referred to as an electronic communication service. And what the Commission or the European Union has done through the European Electronic Communications Code is essentially broaden the concept of what is a communications provider from a historically technical conception of those that actually operate networks and provide transmission services to a concept that embraces a much broader range of over-the-top communication service providers. And they adopt this rather clunky phrase, interpersonal communication services, to describe those services. Now, so what is the obvious question? Well, from a European Union perspective, that actually has very serious implications in terms of the obligations of service providers vis-a-vis law enforcement and the demands of law enforcement for access to data. Because under the old regime, the pre-December regime, many of the services that we know and love, from the Snapchats to the Facebook Messenger to the Gmail, etc., they were considered to be information society services under European Union law, and were subject to a country of origin principle, whereby they were subject to the rules of the country in which they're established, and were essentially free of additional regulation to supply those services into the other 26 member states, or I'm going to still pretend we're part of the European Union, the 28 member states that we're still missing. But when those OTT communication services have been placed in the telecoms bucket, European legal rules change completely. It goes from a country of origin principle, so one to many, to a country of destination principle, whereby those service providers are required to comply with the laws of every one of the 27 member states into which they offer services. And that trigger has raised great consternation amongst the service providers, the Facebooks, the Googles, the Pinterest, the Apples, all of those companies, the Microsofts that had built a service provision model based on locating their headquarters in Ireland, generally, not exclusively, but Ireland has certainly been the most popular country of establishment, and supplying services into the other 26 member states. Suddenly, the situation has changed. They now have to comply with the laws of every country into which they provide services. And one of those compliance obligations is about responding to law enforcement requests. And this includes, for example, becoming subject to the GDPR's lesser-known cousin, the Privacy and Electronic Communications Directive. And that directive, which is applicable to, or part of it is applicable to providers of electronic communication services, regulates or at least touches upon the obligations of service providers vis-a-vis surveillance, interception, monitoring of communications, and placing controls on the ability of providers and the abilities of the state to engage in surveillance and to make demands of these operators. So in terms of regulatory jurisdiction, service providers, particularly the OTT service providers, have undergone a radical change in Europe within the space of since December 2020. Now, to what extent that maps to criminal procedure, criminal jurisdiction, in terms of to what extent, you know, a service provider being a regulated electronic communication service provider and being subject to the laws governing interception depends, of course. We don't have a single rule. In countries such as Belgium and I'm going to say the UK because the UK is another example before we left the European Union, we don't have an alignment. The notion of whether a service provider is subject to criminal procedure for interception does not depend on their categorization as a regulated operator. But in fact, the majority of European Union member states, Germany, Italy, Spain, France, the largest jurisdictions, having moved into the regulatory jurisdictional bucket and being regulated as a telecoms operator, that has also generated obligations to comply with law enforcement requests that didn't exist previously. So global provision has come with a new compliance burden for service providers since the 21st of December 2020, specifically with respect to law enforcement requests. And those law enforcement requests are very extensive because, as I've said already, communication service providers generate extremely valuable forensic data. From the obvious examples of content, we have the attributes of our communications activity, referred to as traffic data under the Privacy and Electronic Communications Directive. We have subscriber data, a whole series of incredibly rich forensic material that law enforcement want to get access to for the purposes of their investigation and enforcement of law. Now, on what basis does a service provider disclose information to a law enforcement agency, particularly if their regulatory status doesn't align with their criminal jurisdiction status for purposes of interception? And broadly speaking, we can see four categories of basis for service providers to disclose information to law enforcement. One is voluntarily. Clearly, service providers may choose, they identify information about criminality and they want to get rid of that activity or to get the perpetrator, and they disclose it to law enforcement. Most service providers will include within their terms and conditions the ability to disclose information to law enforcement, sometimes only in response to a legally binding order, but often they will reserve some right to disclose for other reasons, including breach of their contractual terms. Second category is voluntary, but within a legal framework. And here what I mean is we have rules that encourage or can effectively encourage service providers to disclose voluntarily. The Data Protection Act 2018 in the UK, the Crime and Courts Act 2013. In both cases, service providers are given immunity from liability if they voluntarily disclose in the course of assisting the prevention and detection of crime. But it is still voluntary in nature. Then we go into what I would describe as mandatory through liability. In some jurisdictions, and an example would be Italy, service providers actually have an obligation to report certain types of criminal conduct. In the Italian example, it's child sexual abuse material. And if they fail to report that material, then they become liable for that failure. And therefore, the incentive, it's a push of data from the service provider to law enforcement rather than a pull of data from the service provider to law enforcement. And that pull occurs in my last category, mandatory through request, where essentially we're talking about interception warrants, demands for communications data, mandatory authorization procedures permitting law enforcement to demand information. But if we take those four categories, voluntary through voluntary but within a legal framework, mandatory through liability, mandatory through request, that variety needs to be multiplied clearly within an environment where you have a cross-border service provision. So, for example, one of the implications of the Cloud Act is that there is the possibility that, for example, UK law enforcement can go direct to Google Inc. or Facebook Inc. or whichever Inc. you want to demand information about subscribers, non-US subscribers. Now, that may be a mandated request under UK law and is a mandated request under UK law, but from a US law perspective, it's voluntary. There is no requirement to disclose, and therefore part of the conflict that the operator faces is not simply one of breaking the law, but it's about choosing whether to accept the mandation from one jurisdiction or exercise its voluntary situation in the same situation. So we have this complicated framework. And this complicated framework is, of course, made more complicated by the nature of the obligations that are placed upon service providers by law enforcement under national regimes, and those national regimes having an extraterritorial effect on service providers offering services into the jurisdiction. And there are the obvious operational obligations placed upon service providers, such as preserving data or producing data in response to a warrant. But of course, we have to bear in mind that there are other types of obligations, what I refer to as facilitation obligations imposed upon service providers, which include the building of an intercept capability. So to what extent does the law in the jurisdiction require a service provider to build its network, to develop its service in a way that facilitates the disclosure of information in response to a subsequent production order or warrant? And this was an issue that came up in the Skype case in Belgium, where Skype was asked to intercept content by the Belgian prosecutor. Skype's response was, we can't do it because our network's not built like that, and therefore we can't be held liable for our failure to do it. And the Belgian court's finding that, that is not a defense. You should be technically organized in such a way such that you can comply with the request if you've not built your network, even though you operate out of Luxembourg, but because you are supplying services into Belgium, you will be liable for that failure. And another example of that is data retention, retaining data for the, again, potential subsequent request made by a law enforcement under a warrant or some other form of order. And only last week, we saw this situation where in France, the Supreme Court held that French data retention laws were justified. And in the same week, the Belgian Constitutional Court decided that they weren't. Going back to the compliance obligations of service providers operating in a global marketplace, if I'm subject to an order to retain data for subsequent law enforcement disclosure, there's clear uncertainties about the validity of data retention in different regimes within a European market, let alone on a global level. So we have this concurrency, we have inevitable conflicts, and both, as I've already said, the Cloud Act from the United States and the E-Evidence Act essentially try to address this through what they refer to as a comity process. And this comity process, as I said, is a second order mechanism for trying to resolve conflicting requirements by imposing a doctrine of restraint on one of the jurisdictions or the requested jurisdiction in favor of another interest. And what both the US and the EU proposals say is it's essentially for the service provider to identify that conflict. So in the US, the Cloud Act refers to the service provider having a reasonable belief and being able to identify a material risk of conflict and then being able to file a motion before the courts. Now, identifying a material risk is clearly can be a clearly problematic issue. Most of you will be familiar with the Microsoft Ireland case, which went all the way to the US Supreme Court, although was never decided upon. But in the course of all of the submissions to the Supreme Court in trying to resolve that issue, the most that the European Commission could say was that they thought there could be a potential breach of the GDPR were this data to be accessible by the US authorities from the Dublin data center. Does that constitute a material risk or simply an opinion of a civil service essentially operating for the European Union. So this is quite an obligation placed upon the service provider. They have to, under the e-evidence proposal, provide reasoned objection. They have to document the nature of that risk. So identifying the conflict lies firmly with the service provider. In terms of initiating the comity process, under the Cloud Act, it is for the service provider to initiate it by filing a motion. So the comity process is commenced within the recipient jurisdiction, the jurisdiction where the service provider is located. Whereas under e-evidence, the initiation is carried out by the issuing authority once the service provider has raised a reasonable objection, and therefore the court that is seized with carrying out the comity balancing exercise is the issuing jurisdiction. So even between these two very new solutions designed to try and resolve concurrency and conflict, we have two very different approaches. But the service provider is absolutely at the heart of that activity in determining whether a conflict exists, whether a process should be initiated. Because clearly, if they identify a conflict, but they decide there is not a material risk, or under European speak, there is no reason of objection, then essentially they hold up their hands and no comity process starts. And last but not least, service providers then get some sort of immunity were they to, once they comply with the decision of the court, and under the Cloud Act, that is a statutory immunity. Under e-evidence, currently it's simply a recital, but I know it's something that's being lobbied upon. So I said at the start that as part of this comity process, this balancing process, what's unique is that service providers' interests are expressly addressed in both Cloud and the EU proposal. They're addressed in virtually identical manner. They focus on two things. One, they focus on the connection between the service provider and the country making the request. So the nature and extent of the ties is the wording used in the Cloud Act. The degree of connection is the wording used under e-evidence. But it's asking the court to make an assessment about the extent to which the service provider is engaged in that country and therefore should be made subject to the laws of that country. Offering services, targeting, having consumers, having users. Those are the sorts of inquiries that would be made. The second interest, the service provider interest that the comity process is recognised is, of course, the possibility of a penalty, whether it be against individuals. And we know from countries like Brazil, individual executives can get locked up because, for example, WhatsApp failed to provide data. Facebook executive gets to spend a night in jail. So this can have an individual victim as well as a corporate consequence in terms of a penalty. And those service provider interests are unique because, or are critical because clearly the court has got governmental interest to consider. It's got interest of the victim and potentially the perpetrator to weigh up. And what the courts are being asked to do is to consider also the service provider interests. So in conclusion, how have service providers responded to this concurrency and conflict? And I just want to note a couple of legal responses and then a couple of non-legal responses. In terms of legal responses, last year, we saw companies like Google and Facebook actually change the legal status of us as UK users, or certainly me as UK user. I used to be provided my Google services and my Facebook services by the island entity, but because of Brexit, Ireland is no longer my controller. My controller is now Inc. And that that change in the contractual status of me as a UK user was precisely to address the concurrency and conflict that exists once the UK left the European Union. Secondly, we have legal challenges taking place. Service providers are actually challenging the rights of foreign governments to make demands of them, and we're going to see more of that, I would predict, over the next 12 to 18 months. One of the things that's particularly being played out in the news at the moment is Facebook's decision to move to end-to-end encryption for its Facebook Messenger service. The government of the US, the UK, Australia, and a number of others have made very public their disagreement with Facebook's technical decision. And non-legal solutions, infrastructure localization. People, the service providers are bringing the infrastructure closer to the customer, and that should reduce the pressure from foreign government access requests. Secondly, they're distinguishing enterprise from consumer users, because the rules governing access to data about enterprise users, both under e-evidence and under US law, are different. They're more they're subject to what is known as a proximity principle, which requires service providers to essentially be a destination of last resort. But finally, in terms of what does this all mean in terms of notions of jurisdiction, service providers, as I said, will be generating the comity jurisprudence, because it will be them that are identifying the conflicts, them that will be initiating the comity process. So I would predict that we will see probably quite a lot of jurisprudence emanating from the United States, not only because they are predominantly US service providers, US dominance of the service provider market, but also because the Cloud Act will allow recipient jurisdiction cases. In terms of the balancing service provider interests in the comity process, I think that's going to be, again, I can't see service provider interests in any way trumping the interests of the states. I think the only area where service providers will get much of a hearing is where you have the individual victims being exposed to legal liability. So with that, I'll stop.